It's certainly our pleasure to be here, and we look forward to today's discussion. First, we're going to talk about recent changes to DOJ's and FTC's review of transactions. Then we'll cover antitrust scrutiny within the labor markets, and we'll finish up with a discussion on recent developments with respect to competitive intelligence and information sharing. But before we begin, we have some housekeeping to attend to, the usual disclaimers. The views and opinions expressed by Peter and myself are our own and do not necessarily reflect the views and opinions of Jones Day. Further, what we say should not be construed as providing any legal advice or in any way implicating an actual or potential attorney-client relationship.
Talking about changes in DOJ and FTC merger enforcement. And there really has been a dramatic change in recent years. A number of years ago in Northern California, Jones Day hosted, along with a GCR, an antitrust in technology. We really had to search to find economists who are willing to stand up for the hipster antitrust view, which is more accurately called the neo-Brandeis view. And in just a few years now, the enforcement trends have shifted from those more traditional views to truly reflect the neo-Brandeis school of thought. And so we see dramatic shifting to expanding the scope of enforcement considerations, including things like FTC Section 5 unfair competition concerns, and bringing those now in both enforcement actions and in merger review. And you see significant enforcement where enforcement is meant to drive policy as far as economic concerns, social concerns, and stepping beyond the more traditional realm of merger review. I think the overall prevailing theme is that there is greater skepticism, and that's greater skepticism of mergers, that they can actually benefit competition, greater skepticism of efficiencies when parties go in to explain why they're doing this, how it's going to make them better competitors. There's a great deal of scrutiny of those claims and greater skepticism of remedies. The agencies have staked out a very clear position that they're not looking for remedies. They're not looking to settle mergers. They're looking to prevent competitive harm through mergers. And so there's much more scrutiny of remedies if they will consider them at all. And so to dive a little deeper into kind of the theories that are getting traction with the agencies that really expand beyond the kind of traditional ambit of merger review. Historically, and when I started as an antitrust lawyer, a lot of the focus was around horizontal overlaps. Do the parties both offer the same product or service? And if they do, how much will that deal increase concentration? There's also some, but very little concern around vertical overlaps. Does one party provide an input that the other party uses to create their product or offer their service? And if so, do they offer that same input to rivals such that they can cut off access to somehow improve their position downstream? And I tell you, horizontal was the primary focus. Vertical was presumed innocuous, maybe beneficial for the most part, but that's where we have really seen a pretty dramatic change in enforcement priorities. And so now there's much more of a focus on things like conglomerate and portfolio theories. Even if they don't have a horizontal overlap or one's not supplying an input into the other one, do they have adjacent products that they can tie or bundle or somehow use, not to necessarily harm consumers under that consumer welfare standard, where are you going to increase prices, reduce innovation? But instead, the question is, are you going to harm rivals? Are you going to make it so rivals cannot effectively compete because they can't compete with that bundle? Maybe they don't offer all the different pieces of it, or maybe you're considered essentially a moat by adding additional elements to your offerings so that for a rival to compete, they have to compete on multiple fronts. We also see more of a focus on what's called a roll-up strategy. That's where a company acquires, through a series of deals, a number of typically smaller competitors in the same field. And if they're small enough, it might be that few or none of those actually get reviewed by the agencies based on the thresholds under which you actually file for merger review. And so the concern here is, are companies, including private equity companies, going around buying up a whole bunch of small firms and ultimately creating a significant or concerning market share through that strategy? There's also an interesting focus on changes in owner incentives. If you're a buyer, do you just simply have different incentives than the seller? Maybe the seller had a strong position in the market, but they weren't very effective about using that. They weren't going around and really maximizing their prices. Maybe they're kind of sleepy and didn't really recognize the potential they have. Control that company, maybe not even a board seat, maybe not even any input in it. Just having a partial ownership of another firm chill your incentives to compete. For example, you'll get part of the returns, that's part of it. Maybe there's also more of a collusion aspect, where does that partial ownership give you some sort of access or insight to the competitively sensitive information for that other firm? For example, do you know what their product roadmap looks like? Do you know what their pricing strategy looks like vis-a-vis that partial ownership? So not just how do companies compete as far as the products and services they offer, but also how do they compete to attract, hire, and retain employees? And so the question is, will a merger allow companies to actually reduce those incentives, to offer less compensation, less benefits, and provide employees with fewer options for where they can work? What's notable about that is historically, one of the very common efficiencies that parties would point to justify a merger is that you're going to be able to streamline certain operations. Oftentimes that meant using fewer employees to do the same amount of output or work, produce the same number of products, or offer the same level of services. Now, that may actually backfire on the parties, because you're telling the agencies that I'm going to reduce the headcount, and therefore maybe I have not just the ability to streamline my operations, but maybe that means I, as an employer, have some sort of market power or the ability to control wages or control competition for labor. And then finally, there's a much more of a focus on non-competes. And this is both non-competes between firms for products, but also between firms and their employees. But there's been a focus on non-competes between employers and employees, which historically hasn't gotten a lot of attention. And with proposed rules from the FTC, it may be that non-competes are only permissible in a very narrow slice. So what does this mean as far as the deals that might be caught by merger investigations? It means a whole lot more of them might get questions, might get second requests. And our audience probably knows, but essentially the way a merger is reviewed is you initially do in the US, if you meet certain thresholds, you file an HSR file, which gives the FTC and the DOJ a chance to review the merger before you close to see if they have any competitive concerns. Are you going to increase concentration? Are you going to tend to create a monopoly? And so historically, as I mentioned before, vertical and horizontal deals between competitors or deals between upstream and downstream firms got some scrutiny. But it means, given the new focus under the guidelines, we expect to see many more conglomerate and complementary firms getting questions. So even if you're not adjacent to each other, vertically related, there may be questions about whether or not your products could be tied or bundled together. If you do a whole bunch of acquisitions, there may be questions about whether or not you are creating essentially market concentration in a way that might not get review if they wait until too long. You might be able to build up significant share without ever giving the agencies a future chance to review any of those deals.